Hello all, let's continue with our series of discussion on important topics in polity for prelims 2023. So this would be our 9th class in the series of discussion. In the last class, we have discussed about the important topics from the topic of federal provisions in the constitution and also from the Indian judiciary. So this class we will discuss about the constitutional bodies and certain other important statutory bodies and few other topics as well. So this series of lecture is especially designed for those students who are preparing and who are appearing for the preliminary examination 2023. And if you are a serious candidate looking to clear your prelims examination 2023, please do not miss out on watching this particular series of lecture. Myself, I have already introduced myself, Babu Gunasekaran. I have secured All India rank 337 in the Civil Services Examination 2016. I was supposed to join the Indian Administrative Service. For certain reasons, it has not happened. Anyways, let us get into the questions and we'll start discussing the questions one by one. Come to the first question. So the first question, because today we are discussing about the constitutional bodies, the first topic would be on the Election Commission of India. The Election Commission of India was considered to be one of the most important constitutional bodies under the Constitution. It has a very important role to play. In fact, you can say the very essence of democracy depends upon the free and fair elections. And in order to ensure a free and fair election, this Election Commission of India was provided under the Constitution. And the very article that deals with the Election Commission of India is Article 324 of the Constitution. So Article 324 of the Constitution provides for the Election Commission. And the very idea with which the Election Commission was established, as I already said, it has to ensure the free and fair election to the election of president, the vice president, to the parliament, which includes both the houses of the parliament, that is to both Lok Sabha as well as the Rajya Sabha, and also to the state legislature, which includes both election to the legislative assembly as well as the legislative council. And in order to ensure this free and fair election to all these areas, the Constitution has empowered the power upon the president to appoint the chief election commissioner and also such other election commissioners as the president may decide from time to time. This means you should have a very clear understanding that the composition of the election commission is not fixed in the Constitution. And who is supposed to decide the composition? The composition will be decided by the president from time to time. It is the president who is going to determine the composition. So he may increase the strength of the commission or he may decrease it also, but today if you see, the Election Commission of India consists of the chief election commissioner and 2 other election commissioners. So in the future it can be increased by the president. In fact, the Constitution only says whenever there are other election commissioner, the chief election commissioner shall be designated as the chairman of the commission. And it is very important that the election commission ensures a free and fair election. That means it needs to have a lot of independence. That's why if you see under the Constitution provides utmost importance to the Election Commission as an institution, and that is one of the reasons as to why the removal of the Chief Election Commissioner is extremely difficult, because he can be removed only in the same manner as that of a judge of a Supreme Court. So you already discussed as to how a judge of a Supreme Court can be removed. It requires a special motion to be passed in both the houses of the parliament and also to be approved by the president in the same session, which is not an easy thing. It requires a special majority as well. So it is the same way by which the chief election commissioner can be removed. But however, the same level of protection is not given to the other election commissioners. Under the Constitution, the other election commissioners can be removed by the president. Other election commissioners can be removed by the president on the recommendation of the chief election commissioner. That is what is given in the Constitution. And what about the service conditions of the election commissioner and the chief election commissioners? It's not elaborately dealt in the Constitution, but rather it is said in the Constitution that the parliament might make a law and they can determine their service conditions. So it is actually the parliament that can make a law and determine the service conditions of these people. So accordingly, the parliament has enacted the Election Commissions Act 1991. So under the Election Commissions Act 1991, the term of the chief election commissioner and the other election commissioners would be a period of 6 years or 65 years, whichever is earlier. Whether they complete the term of 6 years or if they have attained 65 years, and whenever this happens, they cannot continue the office further. So this is what is given in the constitution. And also it is interesting to note that the Election Commission Act 1991 does not give the highest authority to the Chief Election Commissioner. In fact, it says whenever there is a difference of opinion between the Chief Election Commissioner and the other election commissioners, the matter is to be decided by a majority vote. And in fact, their salaries and the other privileges are almost similar, except that the removal of the Chief Election Commissioner is extremely difficult under the constitution, which is not the position with regard to the election commissioners. And also it is very important because we already seen that a recent judgment has been delivered by the Supreme Court, wherein it says, although the constitution says that the president shall appoint the Chief Election Commissioner and the other election commissioner, the constitution says the president can do so unless and until a law is made by the parliament, which can determine as to how the Chief Election Commissioner and the other election commissioners can be appointed. But till this point of time, the parliament has not made a law, and the president continued appointing the Chief Election Commissioner and the other election commissioners, which means he does that based on the aid and advice of the Council of Ministers, which was recently challenged in the Supreme Court. And the Supreme Court has categorically said that henceforth the Chief Election Commissioner and the other election commissioners has to be appointed only based on the recommendation of a select committee. And this select committee is to consist of 3 members, which is to be headed by the Prime Minister himself, the leader of opposition in the Lok Sabha, or the leader of single largest party in the Lok Sabha, and the Chief Justice of India. So henceforth the appointment can be done based on the recommendation which is given by the select committee. So in addition to all these things, you can also understand that the constitution also provides for the appointment of certain regional commissioners who may help the Election Commission of India to carry out the elections in a peaceful manner. And the regional commissioners are also appointed by the president, and the president can from time to time determine the number of regional commissioners. So with this information, let us get into this particular question. Have a look into the question. Which of the following statements is true regarding the Election Commission of India under the constitution? Now, statement 1, the composition of the commission is fixed in the constitution, which can be altered by the president. In fact, the composition is not fixed in the constitution, it is to be determined by the president from time to time. So this particular statement is wrong. Statement 2, the Chief Election Commissioner and the other election commissioners shall be removed in the same manner as that of a judge of a Supreme Court. Now, it is also partially right, but it is partially true, because the Chief Election Commissioner is removed on the same manner as that of a judge of a Supreme Court, but that is not the case with regard to the other election commissioners. So this particular statement is also wrong, which is what we have just discussed. Statement 3, the term of the Chief Election Commissioner and the other election commissioners are fixed to be 6 years or 65 years under the constitution. It is not fixed under the constitution, but rather it is fixed by the Election Commission Act 1991. Election Commission Act 1991. So this is also false. Although the term is right, but not under the constitution. So choose the correct option from the codes given below. So which of the following statement is true? So none of the above statement is true. Now remember, Election Commission is a very important constitutional body, very important for your examination. A lot of things has happened in the current affairs as well. There's a lot of disputes which the Election Commission of India is involved. There's a lot of discussions with regard to the reforms of the Election Commission of India. Recent judgment by the Supreme Court with regard to appointment of the Chief Election Commissioner and the other election commissioners. For all these reasons, it becomes a very important topic. So let us now quickly move to the second question. So come to the second question, and this constitutional body is also equally important for your examination, that is the Finance Commission of India. Now, why this Finance Commission of India has been given a constitutional status, which is given a constitutional status under Article 280 of the Constitution. Article 280 of the Constitution gives the Finance Commission a constitutional status. This is to take care of the fiscal federalism in our country. When we talk of federalism, we have already seen that there is a division of powers between the center and the state. When I talk of fiscal federalism, which also means that there to some extent there is division of powers with regard to the financial powers between the center and the states. In fact, under the constitution, the center has to share certain amount of revenues that it mobilizes through the taxation money to the states. because under the constitution, the states do not have the sufficient means of revenue and the center has more means of revenue. So they have to share a certain amount of revenue with the states. And who is going to determine how much money that the center is going to share with the states? It is to be determined by the Finance Commission of India, an independent body which is given a constitutional status by virtue of Article 280. So if you look into Article 280 of the Constitution, it says that subsequent to the commencement of the Constitution, the President shall appoint the Finance Commission, and the President is supposed to appoint this commission every 5 years at a periodic interval, or even if there is a necessity, even before a period of 5 years. So far the President of India has appointed 15 Finance Commission, which means the latest Finance Commission is the 15th Finance Commission. Under the Constitution of India, the membership is fixed, so it shall consist of a chairman plus 4 members. So this is fixed. But however, what shall be the qualification of these members? The qualification of these members is not fixed in the Constitution. Rather, the Constitution has given the power to the Parliament to determine their qualification. So accordingly, the Parliament has passed what is known as the Finance Commission Act 1951. So under the Finance Commission Act 1951, the qualification of these members has been determined. So there is a qualification for chairman and there is a qualification for the other members as well. So the members would include a retired judge of a Supreme Court or a High Court, and then it may include the other members who are expert in the areas of accounts, finance, and also an academician who is expert in the areas of finance. So all these would be the members of this particular Finance Commission. Now it is very important as to why this particular body is established. The most important function of this particular body is, so when we talk of the function, the first most important function is that they have to determine the way by which the revenue can be distributed between the center and the states. So the first thing is the distribution of revenue. So they have to come out with a formula to identify the distribution of revenue between the center and the states. As per the latest Finance Commission, 41% of the revenue of the center has to go to the states. When I say 41%, not all the revenue, but there is something which is called as a divisible pool of revenue. If you take the revenue of the central government, the revenue that is mobilized through the tax resources can be divided into divisible and a non-divisible pool. So out of the divisible pool, 41% should go to the states. So this is just the vertical distribution. But the Finance Commission in turn will also say as to how this 41% of revenue has to be shared in turn along with the states. So second thing, they will also talk about the grantee aids that can be given to the states. So how much grantee aid then be given to the states? This is in addition to this 41%. But grantee aids may not be to all the states, but certain states like this very backward or having a scheduled caste or a scheduled tribe population at a higher percentage, so they are eligible to get this grantee aids. 3. They may also recommend as to how to augment the resources of the state government so that they can give more finances to the panchayat and the municipalities. So this is the third function that they perform, and then finally any other matter regarding the finances can also be taken up by the Finance Commission on the request of the President of India. So, okay, so these are the major functions that they perform. But however, the most important thing is how do they calculate to what extent the revenue shall be given to the states, and in turn how it shall be horizontally distributed among all the states. If you take the 15th Finance Commission, the 15th Finance Commission has taken 6 criteria. So the first criteria is the income distance. The second criteria is the area of that particular state. 3. Population of that particular state. 4 is demographic performance. 5 is based on forest and ecology. 6, tax and fiscal performance. So these are the criteria based on which the horizontal distribution of revenue among the states will happen. So vertically, yes, from the center to the state 41%, but in turn how much will each and every state will get? That will be decided based on these 6 parameters which is used by the 15th Finance Commission. So what is income distance? Now income distance is the difference between a state which is having a highest per capita income with that of the per capita income of the individual state. So this difference is what is called as income distance. Area is depending upon the territory of a particular state. Population, so in fact in the latest census the population that was, in latest finance commission, the population that was taken into account is 2011 census. So before this there was a practice of using the 1971 census. So some of the states have already raised their issues with regard to this, but however the central government said that this is taken care by the demographic performance. What is demographic performance? You reduce your population, that means you have better demographic performance. Your sex ratio is higher, your literacy rate is higher, so all these are demographic indicators. So better is your demographic indicator, you will be given much reward. So this can actually compensate for using the 2011 census. Second thing is forest and ecology, how much of dense forest a particular state have, and accordingly they may receive more funds from the center. Tax and fiscal performance, what is your tax rising ability, how good are you in your fiscal deficit and all those things. So depending upon all these things the money shall be allocated. Okay, so the Finance Commission of India has a very important role in order to distribute the revenue between the center and the states. So with this information, let us try to solve the questions. Come to the first question. Consider the following statements regarding the Finance Commission of India. The composition of the commission consists of chairman and 4 other members who shall be appointed by the President of India. That is very much true. So the composition is fixed and it consists of chairman and 4 other members. But however, their qualification is not mentioned in the constitution. Their qualification is through the Finance Commission Act. Statement 2. The main function of the commission is to recommend the net distribution of revenue between the center and the states. So this is also true. Not just the vertical distribution, but also the horizontal distribution among these states, and we already seen 6 criteria was used by the latest Finance Commission to distribute this. Come to the last statement. The 15th Finance Commission recommended 41% of taxes to be given to the states from the divisible pool of revenue. So this is what I am saying, divisible pool of revenue, after taking into account the income distance, area, population, demographic performance, forest and ecology, tax and fiscal policy. So this is also true. Which of the statements given above are correct? So the correct statement would be all of the above. So if you prepare holistically the topic of Finance Commission, you can answer any question that can come from this particular topic. Let us move to the next question. The next question is related to the office of the CAG. In fact, the office of the CAG is very important. There is also a present context to this particular question. Recently, the CAG has raised a red flag with regard to the financial status of most of the states. But otherwise also, the office of the CAG is very important for the examination. Article 148 of the Constitution gives constitutional status to the office of the CAG. In fact, if you look into the debates in the Constituent Assembly, Dr. B.R. Ambedkar has said, if there is an office which is very important under the Constitution of India, that is the office of the CAG. In fact, he said that it is even more important than the Supreme Court of India and also the Election Commission of India, if not more important, at least equally important to these offices. Why? Because the CAG plays a very important function of ensuring the financial accountability of the government to the Parliament. Now, how do they ensure this financial accountability? Let us try to discuss that. And in fact, the CAG is called as the guardian of the public purse, because as we have discussed, they ensure the financial accountability of the executives to the legislature. So what is the main function of this particular CAG? The function of this particular CAG is to audit the expenditure and the revenue of the government and consolidate this audit and submit it to the President. And once they complete this audit every year, once they submit it to the President will submit this particular report to the Parliament. And to be very specific, it is submitted to the Public Accounts Committee in the Parliament. And the Public Accounts Committee scrutinize these reports and they can question the government. In this way, the CAG ensures the financial accountability of the government to the legislature. The CAG makes sure through his audit if there is any wasteful expenditure, if the money has been spent unauthorizedly, all these things will be brought in the CAG audit and a note will be made, and subsequently it is placed in the Parliament and the Parliament can question all these things. and that's why the CAG plays a very important role, and he is also considered to be a friend, philosopher and guide to the Public Accounts Committee. Now let us try to understand some of the constitutional provisions of the CAG. So under the Constitution of India, it is the President who has to appoint the CAG. The President will appoint the CAG. His service conditions are to be determined by an Act of Parliament. So accordingly, the CAG Act 1971 has been passed. In fact, the CAG is also the administrative head of the Indian Audits and Administrative Service. So people who are in the Indian Audit and Administrative Service, they all work under the office of the CAG. And most importantly, to provide independence to the office of the CAG, it has been mentioned that the service conditions of the CAG shall not be varied to his disadvantage. That is not at all possible. So once appointed with certain service conditions, subsequently those service conditions cannot be varied to his disadvantage. The salary of the CAG, his pensions and other office expenditures of the CAG are charged upon the Consolidated Fund of India. So we already seen what does it mean by charge expenditure. Charged means it cannot be voted in the Lok Sabha, and not only it cannot be varied to his disadvantage and the expenditure is charged, the CAG is not eligible for any further employment under the Government of India. Further employment either under the Government of India or under the government of any of the state. Now as per the CAG Act, he can occupy an office. His term is for 6 years or 65 years, whichever is earlier. So all these things are to ensure a certain amount of independence, and in fact the CAG can be removed from his office only in the same manner as that of a judge of a Supreme Court. So with all these informations, let us try to solve this particular question. So come to the first statement. The service conditions. So which of the following statement is true regarding the office of the Comptroller and Auditor General? So that is the question. So the first statement is saying the service of the Comptroller and Auditor General shall be determined by an Act of Parliament and shall not be varied to his disadvantage during his term of office. So this is very much true. The CAG and his service conditions cannot be varied to his disadvantage during his term of office. The Comptroller and Auditor General shall not be eligible for further appointment either under the Government of India or under any of the state. So this is also to ensure his independence, and he doesn't act in a biased manner for any government. So this is also very much part of the constitution with regard to the CAG. In fact, if you see, the idea of CAG has been mostly borrowed from the Constitution of United Kingdom. They also have a CAG, but the CAG of India is different from that of the CAG of United Kingdom. In fact, the appropriate expression for India, it would be Auditor General, because he is not performing the role of a Comptroller. But in UK, he is also a Comptroller. That means his permission is required to derive the money, to take out the money from their consolidated fund. But in India, the approval is given by the Parliament, by an Appropriation Act. And then the second difference is, in India, the CAG is just a administrative office, or I would say that the CAG is a constitutional body appointed by the government, and he has no relation to the Parliament. Whereas in United Kingdom, the CAG is the person who is appointed as a CAG is also the member of their House of Commons. Okay, so there is actually a difference that exists between India and United Kingdom. So with this, which of the statements given above are correct? So the answer would be both 1 and 2. So now let us move to the next question. So the next question is related to the public service commissions in our country, which is also very, very important. So we'll discuss about the Union Public Service Commission. In fact, if you look into the Constitution from Article 315 to Article 323 of the Constitution deals with the public service commissions. And in fact, what is the need for this public service commissions? It is also a British legacy in our country. What is the need for this public service commission? The need for this public service commission is that there should be some office which is beyond the control of the government, which recruits office at the highest levels to the government, and thereby they can ensure that the meritorious is selected. So the main idea is the merit-based recruitment of the government employees at the highest level. And once a meritorious is selected, then you can have a better administrative system that it can do well in terms of the administration. That is the idea. It has been derived from the British system. So under the Constitution of India, you will see that for the entire country at the union level, there is something which is called as the Union Public Service Commission. and each and every state can have a state public service commission. And apart from that, if two or more states want, they can also have a joint public service commission. While the Union Public Service Commission and the State Public Service Commission are constitutional bodies, while a Joint Public Service Commission is a statutory body, which means it can be established by an act of parliament and not directly under the constitution. And what is the function that they are supposed to play? As we have already seen, their main function is the merit-based recruitment. So, for example, the UPSC is conducting various examinations, including the civil service examination that you all are preparing for. It is to ensure what? It is to ensure a merit-based examination. Similarly, the State Public Service Commission recruits posts to various state services. So, that is to ensure a merit-based examination. Although with regard to the state services, to what extent they are meritorious can be little questionable, but with regard to Union Public Service Commission, it is very much trustworthy and a credible institution. Now, this is the main function that they are supposed to perform. But however, if you look into the other functions and the other provisions in the constitution, let us try to quickly understand the other provisions as well. With regard to the qualifications of these members who are appointed to this Public Service Commission, the constitution is very much silent about all those things. The constitution only says anybody who is appointed to these service commissions should have a minimum experience of 10 years in the government service, and that too only for the half of the members. The half of the members should be served either under the government of India or under the government of state for 10 years. The remaining half of the members can be appointed by the government. Anybody who is appointed to the Union Public Service Commission shall hold office for a period of 6 years or 65 years, whichever is earlier. In case of State Public Service Commission, it is 6 years or 62 years, whichever is earlier. The members who are appointed to this commission can also be removed from their office. So, what is the procedure by which they can be removed from their office? The constitution provides for 4 grounds as to how they can be removed. If they have engaged in any form of misbehavior, although what is misbehavior is not completely defined in the constitution. If these members engage in any form of misbehavior, then the incident of misbehavior has to be reported by the government to the Supreme Court. Rather, the president will refer this particular matter to the Supreme Court. And after referring the matter to the Supreme Court will give its opinion, and subsequently the members can be removed. If the Supreme Court recommends to remove them, so then the president can remove the members from the service. So, 1 is on the grounds of misbehavior. 2, if they engage in any paid employment outside the office. If they are employed outside the office, which is a paid employment, that is also a ground for their removal. 3, if they become an undischarged insolvent, then also they can be removed. 4, if they suffer from any infirmity, physical or any mental disability, which prevents them from performing their duty. So, that is also a ground for their removal. But however, it is very important that you understand, in case of the misbehavior, the matter has to be referred to the Supreme Court. But in all the 3 cases, the president can remove them directly. And it is also noteworthy that you remember, while the members of the Union Public Service Commission are appointed by the president and the members of State Public Service Commission are appointed by the governor, but be it a member of UPSC or a member of State Public Service Commission, they are all removed by the President of India. So, this is something that you will have to remember. And the constitution also prohibits their further employment, especially with regard to the chairman of Union Public Service Commission. The chairman UPSC has no other place to be appointed in the government, either under the government of India or under the government of the state. But for others, be it the members of UPSC, the chairman of State Public Service Commission or the members of the State Public Service Commission, they can be appointed in certain capacity. So, there is no complete scope with regard to the reappointment, but there is a scope for further appointment. So, there is a difference between what is further appointment and reappointment. Further appointment means you are appointed to some other capacity, but whereas reappointment means you are getting appointed to the same capacity. For all these members, there is no scope for reappointment, but further appointment is possible. subject to certain conditions. But for the chairman UPSC, he has no scope for further appointment. He cannot be appointed in any capacity under the government of India or under the government of the states. So every year, the report of the UPSC and the State Public Service Commission has to be submitted to the president and the governors respectively, and they in turn will place these reports in the houses of the parliament and the state legislature. So these are all the various constitutional provisions with regard to the Union Public Service Commission. So come to the first statement. Though the members of the Public Service Commission in case of union and the states are appointed by the president and the governors respectively, they can be removed from the service only by the president. Yes, this is very much true. And we have already seen 4 grounds on which they can be removed. Statement 2. The members of Public Service Commission is prohibited from holding any further employment either under the government of India or under the government of the states. That is not true for everyone. Only for the chairman UPSC, he is prohibited from holding any further employment. But let us assume the members of UPSC. The members of UPSC can be further appointed, but not to the same position. A member UPSC can be appointed as a chairman of UPSC or chairman of a state public service commission. So that is very much possible. So similarly, the others can be also be appointed to certain other capacity, but that is not possible for the chairman of UPSC. So the members of the Public Service Commission is prohibited from holding any further employment either under the government of India or under the government of the state. So this is wrong. This is not true completely except for the chairman UPSC. Statement number 3. The members of the Public Service Commission shall be removed on the same manner as that of a judge of a Supreme Court in case of misbehavior. No. A judge of a Supreme Court can be removed by a motion which is passed in both the houses. So there is no need for such motion. It is only that the matter is referred to the Supreme Court of India and the Supreme Court will give its opinion. So this particular statement is also wrong. So which of the statements given above are correct? So the correct statement would be option C, that is 1 only. Let us move to the next question. So the next question is related to the National Commission for Backward Classes. Why this particular question is very important? So we all know that recently the National Commission for Backward Classes has been given the constitutional status. So before the constitutional status, the National Commission for Backward Classes were having a statutory status. When I say statutory status, the National Commission for Backward Classes was established based on the National Commission for Backward Classes Act 1993. So initially it was having a statutory status, but almost the functions that is performed by the NCBC today is also the same, except that the NCBC today has been given a constitutional status. So how they have been given a constitutional status? By virtue of a constitutional amendment, that is the 102nd Constitutional Amendment Act, the year 2018. So the 102nd Constitutional Amendment Act has inserted 2 articles into the constitution. One is Article 338B and Article 338B, along with it has also inserted Article 342A. So 342A. So both these articles are of relevant in terms of the discussion today. In fact, if you see, what is the reason to bring in this Article 338B? Because already the constitution has given the constitutional status to the National Commission for Scheduled Caste under Article 338, and then later a new article was inserted, that is Article 338A, which has given the constitutional status to the National Commission for the Scheduled Tribes. So while already the National Commission for Scheduled Caste and the Scheduled Tribe has been given a constitutional status, why not a constitutional status to the National Commission for Backward Classes? So that is the idea, or that is the reason as to why a constitutional status has been given to the backward classes. So now today it has got a constitutional status by virtue of Article 338B. So under the constitution, the National Commission for the backward classes can have a chairperson plus 4 members. And what is the function they are supposed to perform? Most importantly, they'll have to look into the legal safeguards and the constitutional safeguards with regard to the rights that is guaranteed either under the constitution or under the various laws. Any violation of the rights of people belonging to the backward classes, as we have discussed, either under the constitution or under any provisions of the law, then they can take up these cases, they can investigate these cases, they can also take up cases suo motu or on the basis of complaint, and they can recommend the government with regard to the remedial measures. In addition to that, they can spread awareness with regard to the rights of these people. They can initiate policy research and they can advise the government. So, all these things are the important functions that is performed by the National Commission for Backward Classes. And in addition to that, Article 342A was inserted on the lines of Article 341 and Article 342. What does Article 342A of the Constitution is saying? That the President shall determine the list of people who would be considered to be the backward classes in the country, and subject to the amending powers of the Parliament. So, this is what Article 342A of the Constitution is saying. Now, this was recently subject to the debate and question in the Supreme Court, and the Supreme Court made it very clear after the provisions of Article 342A. Now, who can determine the backward classes for the entire country? It is only the President who can determine, subject to the amending powers of the Parliament. Now, many states were not happy with this particular judgment because they thought that it is going against the federal provisions of the Constitution. In fact, all these things happened because the lack of clarity with regard to the words that was used in the Constitution when the Parliament has amended the Constitution. Earlier, there was a practice that there is a central list which is prepared by the central government, and there is a state list with regard to OBCs which is prepared by the states. So, the central list is used for the central government jobs, that is reservation in the central government jobs, and the state list is used for the reservation in the state governments. And then now the Supreme Court has said few months back that now it is only the President who can determine the list subject to the amending powers of the Parliament by virtue of Article 342A, which was not acceptable to number of states, and the centre also said they had never had this intention of doing this. So, in order to nullify this particular judgment, the Parliament has amended the Constitution again, and they brought in the 105th Constitutional Amendment Act, the year 2022, and now they have added a proviso and explanation to Article 342A, and they made sure that the centre will make the list only for the central services and the state can have their own list. So, which is reverting back to the previous position. So, for all these reasons, the National Commission for Backward Classes is very, very important for this year's examination. So, come to the following, let us go and read the following statements in the question. So, which of the following statements are true regarding the National Commission for Backward Classes? Presently, the National Commission for Backward Classes enjoys a constitutional status by virtue of 102nd Constitutional Amendment Act, yes, because this has inserted Article 338B. So, this is very much true. Statement 2, after the Commission was given the constitutional status, it has taken away the rights of the states to determine their own list of backward classes who may be entitled to get reservation in the state government jobs. So, this was initially what was held by the Supreme Court, but now it has been nullified after the 105th Constitutional Amendment Act in the year 2022. So, this is not right presently. So, choose the correct answer from the codes given below. So, the correct answer is, it is looking for the right statement. So, the answer is one only, that is option A. The next topic is related to the National Commission for Women. So, let us answer and let us try to understand certain information with regard to the National Commission for Women. The National Commission for Women today in our country is very, very active with regard to the protection of rights of the women. In fact, what is the idea behind establishing this particular body is to protect the rights of the women, both which is given under the Constitution and also under the various laws in our country. And in order to do this, perform this particular function, the National Commission for Women was given a statutory status. Under the National Commission for Women's Act. Women Act 1990. So, under this particular act, the National Commission for Women is established. So, under this particular act, the commission shall consist of a chairperson plus 5 members. But however, the act mandates out of these 5 members, one should be from a scheduled caste and one should be from a scheduled tribe. So, this is mandatory. So, what is the reason as to why this National Commission for Women is established? is, as we have already seen, that they have to safeguard the constitutional rights and the other legal rights that the women enjoy in this particular country. Any cases of violation of their rights, the National Commission for Women can take up those investigations. They can also take up cases on suo motu or on the basis of complaints. A number of cases are related to the Act's prohibition of violation of fundamental rights, or related to the Dowry Prohibition Act, or related to the Domestic Violence Act. A number of these cases are taken by the National Commission for Women. And they have been very active, to be very frank, and they can recommend the government as to what kind of remedial measures can be taken. Okay. So recently also a number of incidents has happened where the National Commission for Women has served notice to various bodies with regard to violation of rights of the women. It is also noteworthy that the National Commission for Women has been very influential in bringing certain legislations like the PNDT Act 1994 and making changes in the Dowry Prohibition Act. Now, PNDT Act is the Prenatal Diagnostic Techniques Act, which makes a punishable offence to identify the sex of the fetus in our country. So, all these legislations were brought in based on the policy research and the advice which is given by the National Commission for Women. So, to summarize, what is the role that they play? They protect the rights of the women, both constitutional and legal. They carry out research, give advices to the government to make policy changes, and they also spread awareness with regard to the rights of the women. So, all these functions are performed by the National Commission for Women. So, in this context, we will just try to understand we will try to identify the answer for this particular question. Presently, the Commission enjoys a statutory status as it was established on the provisions of National Commission for Women Act 1990. So, that is true. So, presently it has a statutory status. Initially also it has a statutory status. And there is also a lot of debate that is going on in our country that there is a need to give a constitutional status to the National Commission for Women. That is a debate that is going on. Statement number 2. The commission shall consist of a chairperson and 5 members, provided at least 1 member each from the scheduled caste and scheduled tribe. So, this is also the provisions of the law. So, this is also very much true. So, what is the answer to this particular question? It is asking which of the following statement is correct. So, the answer would be both 1 and 2, that is option C. Let us move to the next question. The next question is related to the Central Bureau of Investigation. Why this CBI as a topic is very important? Because there is a lot of news that is there in the current affairs. Yesterday also there was a news where the CBI has questioned Mr. Arvind Kejriwal. Before that the CBI has questioned Mr. Manish Sisodia, and there is a lot of other news that is also there. And there is also a general news which is saying there is a general allegation that the government is using the CBI to suppress the voice of dissent in the democracy. For all these reasons, CBI is very, very important. But what is a CBI? CBI is the premier investigating agency of the central government. Today, various states have their own state police. The state police is the investigating agency for the state government, whereas for the center it is the CBI. And what is the genesis of the CBI? For which we will have to go back to the year 1941. In 1941, this was a time of the Second World War. There was a war department under the government, and there was a lot of corruption in this war department. And to look into this, in 1941, a special body was established, which is the Special Police Establishment, SPE. And what is the duty of the Special Police Establishment? To look into the war corruption. And it was the Special Police Establishment was placed under the War Department. And this Special Police Establishment was very successful in investigating the cases of corruption. And then the government thought, why don't we expand this to all the department across the government and to look into the corrupt activities of all the government servants. And that is when the government has passed the Delhi Special Police Establishment Act 1946. And by the Delhi Special Police Establishment Act 1946, now they expanded the scope of this Special Police Establishment to all the government servants, especially in the capital region. And then in the year 1963, this is very important, in the year 1963, the Special Police Establishment was renamed as CBI, and it was transferred to the administrative control of the Home Ministry. But still they continue to derive their powers from where? They continue to derive their powers from the Delhi Special Police Establishment Act. It is that the name has been changed. Now it has been expanded to all the government servants, not only the government servants, but also to the public sector undertaking and also to the private individuals who are engaged in the corrupt activities. So in 1963, it was renamed as CBI under the administrative control of Home Ministry. But today it is under the administrative control of the Department of Personnel. Department of Personnel, Ministry of Personnel, Pensions and Public Grievances. So this is the background, and if you see today, the CBI over a period of time has enlarged the scope on which it can carry out the investigation. So it carries out investigation on high profile criminal cases. It carries out investigation with regard to the corrupt activities of the government servants. It carries out investigation with regard to the economic offences in our country, the high profile economic offences. It carries out investigations with regard to the cases that affects the national security of India. It carries out investigations with regard to the international crimes and the international laws. So in all these cases, the CBI carry out the investigation. Today, CBI is headed by an officer of the rank of director, who should be given a minimum term of at least 2 years initially under the directions of Supreme Court, but now under the CVC Act 2003. So this is to ensure some kind of stability to the director to carry out investigation on various matters in order to avoid the political interference. So these are all the basic information that you should remember. But otherwise also, why this particular topic is very important, because in the news there is something which you can also read, is something which is called as the general consent that is to be given by the states. Now what is this general consent and how that is related to the topic CBI? Now when this Delhi Special Police Establishment was passed, the idea is to empower the Special Police Establishment, which is today called as a CBI, which is under the control of the Ministry of Personnel, to look into all the cases of corruption of the government employees only in the national capital region. But however, over a period of time, they have expanded in their functions, and the government employees also function in different parts of the country. So the CBI is also empowered to look into the corruption charges against those government employees as well, but provided if the permission is given by the concerned state government for the CBI to carry out the investigation in those areas, for which each and every state used to give what is called as a general consent. And this general consent is mandatory under Section 6 of the Delhi Special Police Establishment Act. Delhi Special Police Establishment Act. Unless and until the consent is given by the concerned state government, the CBI cannot enter and carry out these investigations. So this is the understanding that you should have. Today, because of the allegations that the CBI has been misused to victimize and to harass the people from the opposition party, many states started to withdraw their general consent that they have been giving to the CBI. And almost 8 to 9 states in our country has started withdrawing the general consent. That means they have said that we will not give a general consent, which is an approval which is given by a state for a period of 6 months. For all the cases, the CBI can come and start investigating these cases. Now the states are saying that we will not give you general consent, but we will give you consent on case-to-case basis. Okay. So for this reason also, this CBI has been very much reported in the newspaper. So with this information, let us try to solve the question. First statement, look into the first statement. The first statement says, while the National Investigation Agency has jurisdiction over the entire country, whereas the Central Bureau of Investigation cannot investigate into the cases in the states without the consent of the states. So this is very much true. That's why you need the general consent, which has been withdrawn by the number of states, including the states like Andhra Pradesh, Kerala, and the states like Telangana and some of the northeastern states. They have already withdrawn this general consent. Whereas if you look into the National Investigation Agency, the National Investigation Agency was established by the NIA Act in 2008. After the Mumbai terror attack, they wanted a specialized body to carry out investigation on the terror related cases, which was earlier done by the state police. They thought that you need to have a specialized agency. And when the act was passed, they have given the power to this agency to carry out investigations without the consent of the states in all the states. So in fact, the first statement is right, so which is there in case of NIA, but that is not there in case of the CBI. So this particular statement is true. Statement 2. While the National Investigation Agency is a statutory body, the Central Bureau of Investigation is only a body established by an executive order. This is very much true. The National Investigation Agency is established by the NIA Act, whereas the CBI is established only by an executive resolution that was passed by the Home Ministry in 1963, which has now been transferred to the Ministry of Personnel, although they continue to derive their powers from the Delhi Special Police Establishment Act, but still it is only a statutory body because of the way it has been established. So this particular statement is also true. Which of the statements given above are incorrect? So the incorrect option would be neither 1 nor 2. So let us move to the next question. So the next question is related to the Model Code of Conduct. Again, a very important topic for you to remember few information which at any time can be asked in the examination. Now, what is this Model Code of Conduct? For which we'll have to go to Article 324 of the Constitution. Article 324 of the Constitution provides for the Election Commission of India, and why this Election Commission of India is given the constitutional status? They have to ensure a free and fair election. In fact, today the Election Commission of India relies upon the Representation of People Act. The Representation of People Act 1950 and 1951. Mostly the Representation of People Act 1951 to ensure a free and fair election. But there are certain things which is not completely covered, and still the Election Commission of India needs to do all those things, and one such thing is which is called as the Model Code of Conduct, which also helps the Election Commission of India to ensure a free and fair election. So what is this Model Code of Conduct? So to put it in a simple way, you can say these are certain do's and don'ts that should be followed by all the parties and the individuals who are carrying out in the contesting election in the any form of elections. So this is basically what is this Model Code of Conduct. So everybody has to follow this do's and don'ts or a set of guidelines that is issued by the Election Commission of India that would help the Election Commission of India to ensure a free and fair election. That would help the Election Commission of India to provide a level playing field to all the candidates who are contesting the election. So where did it all start? It all started in 1960, where the state government of Kerala came out with certain guidelines with regard to the elections in that particular state. Taking a cue from there, then in 1970s, the Election Commission of India came out with certain Model Code of Conduct. And how do they make this Model Code of Conduct? Before the start of the election, the Election Commission of India would call upon the meeting of all the political parties, and as a general consensus, they come out with this particular guideline. So that is how they come out with this Model Code of Conduct. And what do they normally regulate? They regulate the entire process of electioneering. What do I mean by electioneering? By electioneering, I mean how the political parties would carry out the election procession, how they would engage in the election canvassing, the political speeches and all those things. So certain general guidelines are given by the Election Commission through the Model Code of Conduct. It not only includes these things, the Model Code of Conduct today also covers the election manifesto. The Model Code of Conduct today also carries out regulations with regard to the freebies, the misuse of government vehicles and the government resources by the party in power. So all these things are covered under the Model Code of Conduct. So the idea again is to ensure a free and fair election. But then the question is whether this Model Code of Conduct, are they legally enforceable? Are they legally enforceable today? And the answer to this particular question is the Model Code of Conduct is not legally enforceable. And that's why the critics also say the Model Code of Conduct is nothing but it is just a moral code of conduct. But however, if you ask the opinion of the Election Commission of India, they want this Model Code of Conduct not to be legally enforceable, because that will help them to put some kind of pressure to the political parties at the same time to complete the election process within the specified time limit. And however, the Election Commission of India has made it very clear, if they wanted to enforce any of these Model Code of Conduct, they can enforce them by invoking the respective provisions from the Representation of People Act 1951 and also from the Indian Penal Code. But however, they are happy with having a code which is not legally enforceable, because whenever there is a violation of the Model Code of Conduct, the notice will be served, and many times an immediate compliance has been given by the political parties, and thereby they can complete the elections in a timely manner. So whenever the Model Code of Conduct is brought in, what is the time period for which this Model Code of Conduct is in force? The Model Code of Conduct will be in force once the election schedule is announced by the Election Commission of India, and it continues to be in force till the time the election process is completed. So, this is the understanding that you should have with regard to the Model Code of Conduct. With this information, let us try to get into this particular question. So, look into the first statement. Statement 1, the Model Code of Conduct. Okay, so let us first read the question. Consider the following statements regarding the Model Code of Conduct circulated by the Election Commission of India during the elections. The Model Code of Conduct is legally enforceable? No, it is not legally enforceable, because we have seen that it is equivalent to that of a moral code of conduct. For its violation, as it has a strong statutory backing. No, it does not have any statutory backing. The code comes into force as soon as the election notification is issued and remains in force till the conclusion of the election. So, which of the statements given are true? So, it does not come into force as soon as the election notification is issued. Election notification is different, election schedule is different. Election notification comes, and then after some time the election schedule will be announced by the Election Commission of India. So, the Model Code of Conduct comes into force only after the election schedule. So, this is also wrong. Which of the statements given above are incorrect? So, the incorrect option would be both 1 and 2, that is option C. Let us move to the next question. So, the next question is related to the Advocate General of the states. We have already seen a topic on the Attorney General. So, similarly at the state level, there is a highest law officer in the state, that is none other than the Advocate General. Again, a very important question, a very important topic, for which you will have to remember all these articles. You will have to remember Article 165 of the Constitution, and then you will have to remember Article 177 of the Constitution, and then it is also relevant that you remember Article 194 of the Constitution. So, all these things are one way or the other related to the Advocate General of the states. So, Article 165 of the Constitution says that the Advocate General shall be appointed by the Governor, and he holds office during the pleasure of the Governor. So, normally he is appointed for a period of 3 years. And who is usually appointed as the Advocate General is someone who is eligible to be appointed as a judge of a High Court. And what shall be his service condition? Everything shall be determined by the Governor. But however, please understand, the Advocate General holds office during the pleasure of the Governor. That means he can be removed at any point of time. And what is the function that the Advocate General is supposed to perform? He is the highest law officer of the state government. He is supposed to defend the state government in a court of law. Now, in this regard, he has the right to audience any court within the territory of the concerned state. And Article 177 of the Constitution says that he can also take part in the proceedings that happens in the state legislature, because sometimes you will have to defend legally the government in the state legislature as well. So, the Advocate General can go to the state legislature, he can take part in the proceedings in the state legislature, he can be a part of a committee, and he can defend the government. And whenever he is performing these duties, he shall exercise all the privileges as that of a member of a state legislature, which is given under Article 194 of the Constitution. So, this is how all these articles are related to one another. But however, you have to remember under Article 177 of the Constitution, although the Advocate General can take part in the proceedings of the House, he can speak in the Houses, but without the right to vote. He does not have the right to vote in the Houses of the Parliament. So, that is the understanding that you should have. So, does he have the right to vote? No, he does not have the right to vote. No right to vote. So, with this information, just come to the question. Which of the following are true regarding the Advocate General of the state? Statement 1. The Advocate General of a state holds office during the pleasure of the President. No, he does not hold office during the pleasure of the President. Rather, he holds office during the pleasure of the Governor. Sorry. So, this particular statement would be wrong. Statement 2. He has the right to audience in any court within the territory of the concerned state, and also to take part in the proceedings of the state legislature without the right to vote. So, this is true. So, he can take part in the proceedings of the state legislature without the right to vote, and whenever he is taking part, he shall also have all the privileges of that of a member of Parliament. So, which of the statements given above are correct? So, the correct answer would be option 1 only, that is option A. So, let us move to the last question for today, which is again related to something which is there in the current affairs for a long period of time, which is related to the election symbols and the election symbols reservation and allotment order 1968. Now please understand, this election symbols and the allotment order is issued by the Election Commission of India. This order was brought by the Election Commission of India. So majorly to deal with the issues of splits and mergers of the parties, and also with regard to their symbols, the conflicts with regard to their symbols once there is a split and merger of the parties. So with this information, let us come to the question. The election symbols reservation and allotment order 1968 has been reported many times in the context of deciding dispute over the split and mergers of parties outside the legislature. Which of the following empowered the Election Commission of India to pass this particular order? So the question is, okay, there is an order. So what empowers the Election Commission of India to make this particular order? In fact, this question is very, very important because of the conflict that has happening in our country right now. So for example, in Bihar, the Lok Janshakti Party, there is a dispute with regard to the splits and merger of this particular party. You take the Shiv Sena, there is a problem with the Shiv Sena today, and they also fought against the split and merger. The same dispute is also right now going on in the AIADMK party in Tamil Nadu. And this is likely to continue for the other parties as well. So whenever there is a split within the party, how it is to be decided? It is to be decided under this particular order. But what has empowered the Election Commission of India, because it is not mentioned in the constitution, there is no law with regard to this. What has empowered the Election Commission of India to do this? Now, for this, you will have to understand Article 324 of the Constitution. Article 324 of the Constitution says that the Election Commission of India should ensure a free and fair election, and for which Article 324 of the Constitution has given a number of plenary powers to the Election Commission of India, and using its plenary powers, or you can say some element of extraordinary power, they can make rules as well. So the core behind this order, that is the election symbols reservation allotment order, flows from Article 324 along with the reading of Section 29A of the Representation of People Act. Representation of People Act 1951. So what is this Section 29A of the Representation of People Act? The Section 29A of the Representation of People Act allows the Election Commission of India to register the political parties. Register political parties. So it is not only that Article 324, but it also includes Section 29A of the Representation of People Act along with certain rules under the conduct of the election rules. If you see the conduct of election rules, especially the Rule 5 and Rule 10 of the conduct of election rules also deals with the carrying out the elections in a free and fair manner, while Rule 5 talks about that all the candidates should be given the party should be allocated the symbols, and then the Rule 10 talks about the preparation of list for the candidates. Okay, so to that extent, you see that all the three things are involved, based on which the Election Commission of India has come out with this particular order. This is what the website of the Election Commission of India says. So what has empowered the Election Commission to do this? The conduct of election rules along with Section 29A of Representation of People Act and also the Article 324 of the Constitution. So which of the quotes given above are correct? So the answer is all of the above. So with this, we'll end our discussion today. So this is the 9th class of a series of lectures on the important topics for polity for the preliminary examination 2023. If you see what we have covered in all the 9 classes, we have covered the important topics related to the fundamental rights, we have covered the important topics related to the legislature, to the executive, to the judiciary, the center-state relations, the local bodies, the constitutional bodies, statutory bodies. We also touched upon the Representation of People Act and also the current affairs associated with these topics. For maximum benefit, try to watch all these lectures, which can be extremely beneficial to the students who are appearing for the prelims 2023. In the next class, which would be our last class, we will be touching upon certain miscellaneous topics, just not to miss out on any of the important areas. Okay, so try to watch all these videos. All the very best. Thank you very much. Take care. God bless.